Welcome all to today's class on the case law of Indira Gandhi versus Narain for administrative law. This is Dr. K. Sangeeta. First, if you see the citations, the petitioners and the respondent, it is Indira Gandhi versus Narain and another. The date of judgment was 7/11/1975. If you see the bench of judges, it is Roy, Khanna, Justice Mathur, Beg and Chandrachud. When you see the background, Narain was a political contender against Indira Gandhi for Raebareli constituency in the year 1971 for the Lok Sabha elections. Mrs. Gandhi won the election and the Congress won the house with sweeping majority. However, after the results of the poll, Narain filed a petition before the High Court of Allahabad contending that Indira Gandhi has performed election malpractices. On 12th June 1975, the High Court of Allahabad, in its speaking order, with Justice Jagmohan Lal Singh, found Indira Gandhi guilty of misusing government machinery under Section 123, subsection 7 of the Representative of the People Act 1951. Therefore, the court held that Indira Gandhi cannot continue as Prime Minister of the nation. Further, she cannot contest in the election for another 6 years. Agreed by this decision, Indira Gandhi went to appeal this ruling of the Allahabad High Court before the Supreme Court. The Supreme Court, being in vacation at that point of time, granted a condition stay on the execution of 24 June 1975. Thereafter, a state of emergency was declared by then President Fakhruddin Ali Ahmed, citing internal disturbance, but the real reason that led to emergency was the High Court judgment in Narain versus Uttar Pradesh. The Supreme Court, while granting conditional stay, ordered the parties to appear before it on 11th August 1975. However, on 10th August 1975, the President of proclaimed emergency, striking India, passed the 39th Constitutional Amendment Act 1971 by inserting Article 329 capital A, altogether barred the jurisdiction of the Supreme Court from entering the matter. This amendment made the elections of the President, Prime Minister, Vice President and the Speaker of the Lok Sabha unjustifiable in the court of law. Therefore, 39th Amendment was challenged in the Supreme Court in Indira Gandhi versus Narain. The question of issue that came before was constitutional validity of 39th Constitutional Amendment Act 1975. The respondent argued that the said amendment is violative of basic feature of the Constitution. The respondent relied on the 7-judge bench decision given in the Keshwananda Bharati case versus State of Kerala. The respondent, relying on the above, in 1973, the decision contended that the Parliament under Article 368 is only competent to lay down general principles governing the organs of the state. Since the determination is valid and not, it is a judicial prerogative under Article 329 and 136 respectively. The impugned amendment tend to take away the democratic structure of the nation. The said amendment is illegal because during its passage in the House, of number of opposition MPs were maliciously detained under detention law. The 39th Amendment is irrational and does not pass the classification test as to why classification between members holding higher or a lower post is necessary. This amendment is violative of Article 14 of the Indian Constitution. The said amendment not only destroys basic structure, it also endangers rule of law and separation of power. When you see the judgment, the court gave its decision on November 7, 1975. It must be kept in mind that it was the first case when the landmark decision in Keshwananda Bharati was the state of Kerala was applied in the Apex Court. The Apex Court held that the contention of the petitioner and declared the impugned clause 4 of Article 329 capital A as unconstitutional. As the word of Mathur, which said that this clause destroyed essential democratic feature of the Indian Constitution, the resolution of an election dispute by asserting for ascertaining the adjudicative fact and applying the relevant law. He was of the opinion that the healthy democracy can only function when there is a possibility to contest of a free and a fair election. The impugned amendment destroyed the possibility. Therefore, it is violative of the basic feature of the Indian Constitution. According to Justice Chandrachud said, amendment violative of the principle of separation of power is intently transferred a pure judicial function into the hands of a legislature. Further, he was certain that the amendment is also violative of Article 14 as it creates an unequal position of specific members against others. According to Justice Ray, he said that the another basic feature violated by the said amendment is the rule of law, whereas Justice Khanna found that violation of norms of free and fair election. The bench also found the said amendment violative of principle of natural justice, which is Adi Aldam Partam rule, since it denies the right of fair hearing, who is challenging the election of the members mentioned under the amendment. Democracy is a basic feature of the Indian Constitution. The amending body, the Parliament, is not empowered to pass a retrospective law validating an invalid election. This exercise is nothing but an example of despotic use of unrestrained and unfettered power. The said amendment ought to transfer such determining power to the Parliament. However, a legislative body cannot find adjudicative facts like a judicial body. Therefore, in the opinion of the bench, the impugned amendment is nail in the coffin of democracy. Therefore, the varied reasons of the court struck down, saying that the 39th Amendment Act 1975, finding it unconstitutional and violative of basic structure of the Indian Constitution. Now we will see the critical analysis. The decision in Indira Gandhi was brave decision, reminding greedy Parliament its place in the Constitution. The Parliament was taught that they are not alone in the democracy. Judiciary is there to uphold the Constitution and save democracy from harmful actions of the Parliament. The court in this case upheld the principle of separation of powers, which built the check and balance in the democracy. To check there is no sort of encroachment or overstepping of the officials. The government of the day, in order to save itself from the Allahabad High Court's decision, passed a draconian 39th Amendment Act, which was struck down later as unconstitutional. It was of the view that amidst emergency, the judiciary will also kneel down and abandon its duty to uphold the Constitution. However, judiciary resolved the crisis and struck down the draconian amendment passed to validate an invalid election, thus saying supremacy of judiciary. The court proved that Parliament is by law and it is not vice versa. Parliament resent course to establish its supremacy. The attempt to make itself above the Constitution was ruined by judiciary. The court upheld the essence of democracy, the free and the fair elections. The court, at different points in the decisions, reiterated the importance of free and fair election. It held that without a system where the people cannot elect their representative through free and fair contest of election, which is surely not a system of democracy.